For this video, we're going to talk about the trial in a misdemeanor case, what you can expect, how exactly it works, and all those sorts of things. First off, keep in mind, none of this is fair. We've been talking about this from the beginning. They've set this trial date, it's coming up. We have to prepare as if we're going to have it. We have to be ready for it. But what you need to also be ready for is the court can just cancel it and move it anytime they want. If the court date comes along and you're not there, they will issue a failure to appear warrant against you and your driver's license will be suspended. But on the other side, if we get there and the cops aren't there or they don't have their witnesses, well, the judge will just continue it. And I mean, the cop can call in that morning, cat was sick or whatever, and say, all right, no problem. So you need to be mentally prepared that we got trial coming up. You need to be ready, you need to be there. Okay, never mind, it got delayed. Okay, never mind, it got delayed again. They go over and over. I just won a DWI case not too long ago where they just kept resetting it because the prosecutor couldn't get all their officers together. So it's totally not fair, but you just need to be ready for that. The other thing you need to be ready for is even though it's a court date and time, it's not just for you. They're going to stack dozens or hundreds of trials in the same day. So remember, as we've been talking about from the beginning, this is all designed just to funnel everybody through and just get everybody to plead to it, take a deal, and then get on with it. They don't like people going to trial. So it's all designed to make a trial as inconvenient as humanly possible. So what most courts will do is, all right, you got this trial date, we'll schedule 150 people. And they'll just start at the beginning, like, has anybody changed their mind? Anybody ready to make a deal? And they'll start, okay, we'll run those through. Who still wants a trial? Right, all of you? Okay, sit and wait in the back. So kind of your punishment for it is you got to sit there and wait and make it take all day. We're equipped for this. We're ready for this. We're used to it. That's no problem. By the time the trial date comes, we're going to have our arguments down, know the evidence. We'll have all our exact strategy. A couple of things you need to keep in mind in a misdemeanor trial. The judge is going to make the decision. And believe it or not, they don't always follow the law. They don't always follow the facts. I really don't care so much what the specific facts or the specific charges are in your case. At the end of the day, it's going to come down to a coin toss on the judge. And it's going to be affected by their mood, what happened at home. It's going to be affected by, did somebody make them mad earlier in court? One of the things that I don't like to see is we're sitting there waiting for our turn in trial and some idiot on some other case gets up there and running their mouth. And now all of a sudden the judge is all mad and lost their temper and then they call our case. It happens. And so again, that's just part of the risk that you need to understand of if we go to trial, no matter how good our evidence is, there's always a chance the judge will just go the other way. Now, if he does, we can file an appeal, which we'll talk about in the next video. But a lot of folks, from what I've seen, they really don't appreciate that risk that they could lose it. So we're right there in that moment. Now, the other thing you have to keep in mind is most of the time in a criminal case, it's your word versus a cop. And cops lie all the time. I catch them lying. I jump all over them. But at the end of the day, if it's going to come down to your word versus the cop, the judge is going to go with the cop 99% of the time. It's not fair and it stinks. But I don't do you any favors by running you up into trial and trying to prove that the cop is a liar when that cop is in front of the judge all the time. A good example that I give folks is, let's say I've got an argument with your child and I say that your child is a liar and your child in fact is a liar. You're going to believe your child. I don't care what I say. You're going to believe the child over me. And the same thing with the judge. You know, these cops are in front of them all the time. They're going to believe the cop. And so that's what we addressed in the earlier video of taking the plea deal and expunging, because if that's the case, it's us versus the cop, it's going to go to the cop. Now, if it's the type of case where it's your word versus somebody else, you know, let's say you're accused of battery. They said you hit him, you said you didn't. Well, again, we're down to a coin toss. He's believing one of the two of you. And from what I've seen with clients, while they're thinking about it, because they've lived it, and they kind of see it in their head that the truth will come out and the judge is going to go for them, that very well may be the case. You know, we've won plenty of cases that way. But there also is the risk that the judge is just going to go the other way. He's got to believe one of the two of you and then make a decision. So there's a lot of risk that goes into the trial. And that's why we're going to give you our honest evaluation of it. We're going to sit there and go, all right, this is a coin toss, it's 50-50, or hey, the evidence is very strongly in your favor, but there's still a chance to get cut against you. Or in some cases, we're like, look, the evidence is pretty hard against you, and it's most likely not going to go your way. So it's probably not a good idea to go to trial. But if we do that, and you say you want to go to trial, we're going to go and we're going to hit it as full on as we can. So don't ever think that we're afraid of going to trial or that we're worried about it or anything like that. We're just trying to make the best decision to take care of you and protect your freedom. There's a case that I've referenced a few times. We took it to trial. I told the client, the evidence isn't looking good. There's multiple witnesses against you. We should take this deal. The client said, no, need to have the trial and need to prove my innocence. I said, I understand. I don't think that's the best approach, but we'll do it. And boy, we got after that trial. I hit it with everything I had and we won it. So just because I'm telling you, hey, it looks weak, you got some risk, you got some exposure here, that's just how I best do my job to protect you and take care of you. It's not that I'm afraid or I'm not going to go in and do it the best that I can. You're paying me for my judgment and I'll give it to you. We go to trial, we'll have the decision that day. Obviously, you win it, everything's great. If we lose it, then we have to move on and talk about the appeal and how that works, which will be on our next video. Thanks.